Welcome back, everybody, to our latest edition of What's on Tap. I'm Mike Dougherty. I'm the moderator today, and the topic we have for you now is handling commercial loan defaults from workout to judgment. Before beginning, I just want to say thank you to all the folks who have been with us since the very beginning. I've recently looked at the sign-in sheets for here, and I see a lot of familiar names and a lot of new people. So we all appreciate you guys putting in the time to sign on to these What's on Tap episodes. It really helps us put the content out there, and we feel good that we're providing something for you. So with that in mind, let me kind of introduce you to who we have here today. Deane is with us. Cam you've seen from many of the other episodes. He is in our PA in New Jersey office. He's an expert in that regard, in addition to bankruptcy. Andy Condiles is here as well, also PA in New Jersey, an expert in the collection field. So we got a good panel here today. And realistically, you don't want to hear about these guys. You want to hear about the beer. And I am very, very happy about this beer. In the past, I've had to talk about some of the beers. They've been good, but they've not been Delco. For those of you who know, Delco is not just a place, it's a state of mind. It is the best place to grow up in Pennsylvania. It's the best place to live in Pennsylvania. As these guys will attest to, not being from Delco, they just don't get it. So I highly recommend Delco Lager from Aston. Anything from Delco is worth it.
I totally agree, Mike. The people I know from Delco, Mike Dougherty being one, Gritty, the mascot of the Flyers, being the other. I can tell you nothing but the most upstanding citizens come from Delco.
I appreciate the sarcasm on that, so thank you very much. So with that in mind, let's kind of get on with the show. So Andy,
yes.
Talk to us a bit about the formation of a commercial contract. What should be in it? What are some of the things we're looking at to kind of take the people through what we should be looking for there?
Yeah, sure. So first things first, you want to make sure that the party that you're entering into the agreement with is the proper party. You want to get the name right. If it's an LLC, you want to get that name LLC down right, because you want to be able to enforce that contract down the road. And if the name's not correct, you'll have difficulty right off the bat doing that. After from name, you then want to make sure, if there is a board of directors, that the board of directors has signed off on this loan agreement, because there's no assent. Again, you could have some problems down the road trying to enforce the agreement. And then once you do that, you want to kind of think about what is defaults. I mean, the first most obvious type of default is non-payment. But beyond non-payment, there are other instances in which that you may want to define as default. For example, if you're to finance some sort of equipment, if the equipment is transferred to a third party, that could be a type of incident which you would define as default, because you may be comfortable with the original party and let the money to buy the equipment. However, you may not know the person who got the equipment afterwards, and you may not be very comfortable with their credit profile.
Okay, so are you saying, so the default, when you're defining your defaults in the contract, they should be relatively broad?
Right, they should be relatively broad, and they should really try to focus on not just the obvious types of default, non-payment, things like that, but some other circumstances that would really impact the ability of the debtor to repay. Again, maybe using it for a different purpose, transferring to someone, or in a situation where maybe the value of the collateral declines significantly. You may want to get ahead of that type of situation to repossess the property.
Okay. Well, talk to us a bit about guarantees. What type of guarantee should be in the commercial contract?
So guarantees are important because in many instances when the business goes under, when the loan defaults, the business goes under. And if the business goes under, you can get a judgment, but the judgment won't be worth anything. What a personal guarantee does is it obligates the person who signed the guarantee, known as the guarantor, for all of the debts on that loan. So again, if the business goes under, the guarantee allows you to collect both against the business and the individual.
Okay. Now, you mentioned that the name is important. Now, especially the name of the business. Now, I've seen situations, and maybe you have as well, and tell me how this plays out, that if you got a business, Joe's Pizza, but the actual corporate name is Joe's Pizza LLC. Right. Should you have both names, Joe's Pizza and Joe's Pizza LLC, on the contract? What do you recommend there?
Again, I would go back to something broad. The broader the better, because I would say the broader the better.
Okay, so you want to make sure you're covered in both regards, but you definitely should have the corporation name, correct?
Absolutely. If there's some additional name, a DBA maybe, you want to add those two. There's no doubt as to who's actually obligated to this debt.
Now, do you recommend as part of that process that when that loan is being made, that maybe the credit union should be checking to make sure the corporation name is correct, or that they provide the appropriate articles of incorporation?
Yeah, that should absolutely be part of the due diligence, and that's something you want to do upfront before the agreement's entered into, because once the contract's signed, making a change like that becomes much more difficult.
Okay, and what else should we look for in a commercial loan agreement?
Another thing you may want to consider is a confession of judgment. What a confession of judgment is, the function of a confession of judgment is that it permits the creditor to get a judgment against the debtor without going through the typical steps involved in litigation. You've got to go to court, but it's not the typical 8 to 12 month litigation process. It's a much faster process. However, I would note that some states have special requirements when it comes to language of a confession of judgment. So you definitely want to be cognizant of the local and state rules as it pertains to the language of a confession of judgment.
Now, that makes a lot of sense, and I think within that contract, there also should be some reference to a UCC, right?
Well, absolutely, yeah, correct. And UCC, and also if there's specific equipment that's being used as security, you want to clearly define what that equipment is. If there's a serial number, a VIN number, you can't just say it's a red truck. It's VIN number ABC, blah, blah, blah. But that makes it much easier if you've got to go repossess it down the road to identify that collateral and then go repossess it.
And you got to get that vehicle identification number correct, right? That's
correct.
Take your time on that one, right?
Take your time, double check, but you do want to get that correct because that VIN number in the contract is what you're going to use to show a judge to get a replevant order and obviously with UCC as well. Now
that makes sense. Now mentioning UCC, that kind of segues us over to Cam. So Cam, can you tell everybody about what is the purpose of the UCC? Why is it important? Why do we have it in the agreement?
Sure. So just generally speaking, when we're referencing the UCC, we're talking about the Uniform Commercial Code, which is, not to bore you to death, but it's a model set of laws that have been created and for the most part adopted by just about all 50 states, at least portions of that. So the UCC has an entire section related to commercial transactions and secured transactions. As it relates to this topic, we're mostly talking about Article 9 of the UCC, which has been adopted in all 50 states, and it provides a very detailed instruction manual on protecting your security interest in a commercial loan transaction.
Now, Cam, for the UCC, does that apply to personal property and real property or just personal property?
So we're talking about personal property here. When you're talking about real property, most lenders are familiar with getting a mortgage recorded. That's the type of process you're going to follow. It's unrelated to the UCC, but similar in nature in terms of the fundamentals we're talking about. But you're recording a mortgage if you're issuing a secured loan on real property. That is how you protect your security interest. When it comes to personal property, which could be movable property, motor vehicles, equipment, things of that nature, that's where your UCC lien is coming in to provide that security interest.
Okay.
So as I indicated, Article 9 has been adopted in all 50 states, and what you're essentially needing to do is, as Andy indicated, you're going to have a contract that provides a security interest. Once that contract is executed, much like you have to go to the local county where real property is to record a mortgage, in the case of personal property for a UCC lien, you have to file documents to perfect that security interest. In the case of personal property, we're talking about a UCC financing statement. That is a document that's going to be filed and protect your security interest in whatever equipment it is that secures the loan you just issued. Now, also touching on a point Andy raised, and this is something I see in practice a lot, it is really important for your security agreement to clearly identify what the equipment is by way of serial number, clear description of the equipment or property that you're dealing with. But that same information also has to appear on the UCC financing statement if we're talking about just one or two pieces of personal property. Now, there's other types of security interests that can be granted in a commercial loan, and this is pretty common. I know you've seen it, Mike, but it relates to granting a security interest in the business generally. So that is a situation that comes up oftentimes, we're talking about a smaller business who will grant a security interest essentially in all the property owned by the business, all receivables, all assets that the business might have.
Now, Cam, is that called a blanket UCC?
Exactly it. Yeah,
Okay.
that is called a blanket UCC, and we'll have material posted at the conclusion of today's episode to include the entire amount of language, because it's very broad, it's very general, but it is important to get it right. To make sure that you have that language on the UCC financing statement to protect that security interest. So again, see our materials at the end of the episode for an example of that language we recommend to our clients.
Now, and just talking about the UCCs, Cam, so you talked about the filing of it.
Yes.
Is the timing important? So is it first come, first served as far as getting in line for the UCC? So if someone has a UCC behind me, do I have a higher priority, or how does that work?
Yes, so that's treated the same way most liens are. It is a first-in-time priority. So you want to get your UCC financing statement filed as soon as you have it, as soon as that loan is issued, or as soon as practically reasonable, really. It's especially in the case of a relatively medium-sized business or maybe a larger business, they may have multiple locations where they have the same type of equipment, and you don't want that debtor to be, or that borrower to be requesting secured loans with the same equipment being the collateral. So it is important that if you're issuing that loan, first you confirm there is no prior existing UCC liens on the equipment securing your loan, but also you get your UCC lien financing statement filed as soon as possible so that borrower can't go take out another loan on the same equipment acting as collateral.
Well, I think that ties into what Andy was talking about, so correct me if I'm wrong. So when you're actually entering into this commercial contract, is it worthwhile to do a UCC search of that business who's coming to you to apply for that loan to see if there are any outstanding UCCs? Andy, what do you think about that?
Yeah, I think that's a good idea because it gives you an idea of where you might be in the creditor priority order, how much debt this business actually has. So yeah, I think those are some reasons you definitely want to do a UCC search up front.
Okay, that makes a lot of sense. And then Cam, talking about the UCC a little bit more. So you talked about the timing. You want to be, as soon as you get it signed, you want to get it there because first in line is better. So if there's a business that has one location in PA, one location in Massachusetts, you have to file your UCC in both places. Is that fair to say?
Correct. You hit the nail on the head there. Any state or jurisdiction that the business is operating in, if your security interest potentially relates to the assets, equipment, or otherwise that business has in another jurisdiction, you need to file the UCC financing statement locally in each jurisdiction that you might have a security interest. It is important, again, to do that as soon as you can after the contract is formed.
And is it fair to say that's one of the common mistakes you see with folks, that they don't file in each jurisdiction?
That is exactly right. And I recently had a case where it's a business operating out of the state of New Jersey, but they actually own several locations in New York, and that's where a lot of the assets are. And luckily, this creditor knows the rules and they know how to protect their security interests, so we have that UCC financing statement in both jurisdictions. But I've unfortunately seen cases where that does not happen, and because that property has been transferred out of the original jurisdiction where the loan was issued in, that puts the creditor in a worse position to protect their interest.
Okay, that makes sense. And I think we talked about, I want to kind of talk a little bit more about the UCC. So I view a UCC as something, it's visibility, right? So if someone is making a loan, you have the opportunity to look at that UCC to get visibility as to what is that business's debt obligation, not debt obligation, but are there other UCCs out there? So by knowing that, is it important that we get the name right in the UCC?
Yes, just as Andy was discussing related to the contracts, it's just as important to ensure the naming of the business is correct on the UCC financing statement. So oftentimes that can be ABC Corporation doing business as Joe's Pizza, whatever the case may be. It is important that you are fully encompassing all the potential names that the business uses based on how you guys form the contract to ensure that to other creditors out there, more than anything else, that they know your lien exists, and therefore you're not going to have any property become double secured on two different loans. Okay,
and I think we were talking about it before we started here. There's a case you recently had, obviously won't use the real name, but it was a Joe's Pizza situation where the credit union registered the UCC, if I'm not mistaken, under the name of Joe's Pizza, which was the trade name. It was not the business name. And that caused a problem, didn't it?
That's exactly it. And of course, it's an unfortunate situation you only find out a couple of months into litigation about, where you have the defense side bringing up the issue, provide me with the articles of incorporation to show me the actual business name, and that Joe's Pizza, as this example is highlighting, is just a fictitious name being registered in the state. So again, it's important to do your due diligence from the outset at the contract formation to understand who you're actually entering a contract with, and then at the time of recording your UCC liens, making sure that same due diligence is being applied there to get the naming conventions correct.
And I think that's the proper term. When we talk about, Andy, which you talked about in contract formation, Cam, what you talked about as far as the UCC, that's due diligence, right? I mean, that's taking the steps to make sure everything is properly secured, that your interests are protected. And why do you do that? Because now we're going to talk about a default. Exactly. So when a default happens, the first thing I tell folks is a lot of folks here, they handle their consumer and commercial defaults in the same way. And that's just not a good practice. The reason being is, within a consumer default, you've got time. There's always a little bit of time. When you're talking about a commercial default, time is not on your side. So what do we think about in the context of a commercial default? So what do you have? You have a business. So when a business is having hard times, what does that business do? They prioritize. And what they're going to prioritize, they're going to look, okay, I got to pay my employees. I got to pay for goods. I got to pay rent. Some owners might say, I got to pay myself. The owners who, when hard times happen, pay themselves first, that's a huge red flag, so just keep that in mind, folks. You see that happen. When you see the owners being paid first, huge red flag. And then they're going to think about your interest. So that's what happens, right? And when business is having hard times, they're prioritizing. So what you need to do on your end, you need to start viewing that to say, you know what? I need to act fast, because what's going to happen, any sort of asset, any sort of funds are going to be dissipated to things other than myself. So when Andy was talking about all those things you should have in your contract, your financial covenants, your default covenants, when you see these things start to default, you need to act fast. So what does acting fast mean? So acting fast means the first thing you want to do is file review. It's the most important thing. So you know your customer is ready to default. He's already defaulted one of your covenants. You want to pull that loan file. The things that Andy and Cam talked about, you want to look at your UCC. Is your UCC properly registered? Are the names of the business proper? Do you have the names of the guarantors down? I've seen situations where the contract wasn't properly signed. Now's the time to correct those things because the leverage has changed. You can now go to that bar and say, hey, we're going to try and work with you here, but we need certain things fixed. So that's what you're looking doing in the file review. And one thing I highly, highly recommend, when that file review happens, you want to make sure you know every vendor, every creditor that this business has, and you want to get their name, their address, what they owe them. And we'll talk about that down the road, because that's very important to make sure if a default happens, you can grab that. So how do you guys, Cam, how do you view a file review when you're looking at them? What, are you looking for the same type of things?
That's exactly it, Mike. As we've already talked about, there's so many important things from the outset of the contract. That's where I first go to, is to make sure that my client completed their due diligence and got the contract naming conventions correct for the business. The UCC was recorded, things of that nature. I don't just go head first into a lawsuit until I know we actually have a valid claim to be pursuing here.
Which leads to the next point. So before the lawsuit, is there the ability to work something out? Can you set a forbearance agreement? Can you do a loan modification? And what I tell folks when we're going down this road, if you've done your due diligence with the file review, I only recommend a forbearance agreement if you feel the business can right the ship. If they can't right that ship, you got to go right to more aggressive means, because we just talked about that prioritization. You're near the bottom there. But if you feel they can right the ship, what is a forbearance agreement? Basically, it's a contract. You're basically modifying the contract. You're saying we're going to give you a period of time where you don't have to pay. Never recommend more than 6 months, never. But again, it's a legal document, so you got to go through all the normal legal processes. And you want to make sure that it's only no longer than 6 months. And I highly recommend you got to get something. Maybe you get a new guarantor. Maybe you get some additional piece of collateral you didn't have before. But if you're going to go down that road, you got to get something out of it, right? So let's say, for instance, and there was a forbearance agreement, didn't work, you can't do a loan modification, can't do all these things. I really want to tie into some of the things that Andy, you talked about, and Cam, you talked about. So the default has happened. One of the least used methods here within that contract, and Andy, I think you talked about it, but I'm not sure, we talked about the assignment of rents. And in a commercial agreement, you have the ability to grab rents that business is owed from any third party. So I want to play something through with you guys here. So I'm the credit union, and my member has defaulted. And they have a bunch of rental properties where they're receiving rentals. So you guys are going to be the tenants. So what's going to happen is myself as the credit union, as their attorney or even as their person running it, all they need to do is send a letter to you, the tenant, saying you now have to pay me. So we'll start with you, Andy.
Okay.
You're a tenant.
All right.
Some institution has just sent you a letter saying, pay me the rent. Well, how are you going to treat that letter?
I gotta say, I might be a little skeptical. I'd be like, Mike, who? What? I'd be a little skeptical.
Cam, would you agree?
No, yeah, Andy is exactly right. There is no existing relationship more often than not between the tenant and the lender, the secured lender here. So enforcing an assignment of rents can be difficult because of that exact scenario.
And that's the thing. So what happens is you guys have described exactly what the reaction probably would be. If I'm in a rent with my landlord and this third party saying pay me the rent, I might as well just pay a Nigerian prince, right?
Sure. Yeah.
So, but you are entitled. So here's the problem for the tenant, and the tenant's in the bad spot. If the tenant takes the response, takes the letter, trashes it, guess what? The tenant, if he still pays the rent to his landlord, your member business, they owe you too now. So in effect, they're going to have to pay twice. So that is the beauty of the assignment of rents from the credit union's perspective, that they can't just ignore the letter, and if they do it at their own peril. Now, granted, it seems like a harsh result, right? I mean, I have a lease with this person, I timely paid this person, and you third person now want my money, and if I didn't pay you, now I got to pay you both. But that is a remedy that's out there, and I highly recommend you got to start using that, folks. It's a great remedy. Another remedy that's out there, and I think when we talk about assignment of rents not being used much, Cam, this was your UCCs. Mm-hmm. Probably about 20 years ago, maybe 30 years ago when I was first starting to practice, the use of a UCC letter was pretty common. And what a UCC letter is, Cam, you discussed how the UCC got perfected, and we talked about the file review where you're looking for, let's use the instance of, I got a business and one of my vendors owes me $20,000. So during my file review, I found that out. And because we got to act quick, what happens is, okay, they owe $20,000. I know who they are, where they're at. If I have a properly filed UCC, like you discussed, all I need to do is send that creditor or that vendor a letter saying, here's the UCC, you need to pay me the $20,000. That's a great remedy. I mean, what do you guys think about that as far as the ability to collect that easily just from a letter?
Yeah, I fully agree. You're essentially just jumping into the shoes of the debtor that owes you the money and taking over their position as it relates to that other vendor who owes them. So you're essentially usurping their spot and getting first opportunity to recover that money based on your enforcement of, again, it's got to be a properly recorded and perfected UCC financing statement that you've filed to protect that security interest. But assuming you've done everything right, like we talked about in the beginning, this is one of the best remedies out there.
Yeah, and see how, go ahead.
And the other thing I would add is to your point before about acting quickly, this allows you to act quickly as opposed to trying to go back and forth with them for six months.
Absolutely. And you see, folks, how it all ties together from Andy, how you set the contract up, to Cam, how you get the UCC filed, to your file review. That all pieces together for the default so that now you can send that letter out. And for the life of me, I don't know why more people aren't aggressively using their UCCs in this circumstance. And we're not just talking about people who owe money from a vendor context. Investment accounts, we're talking bank accounts not in your institution. So we're talking about the vendors, health savings accounts. There are so many places where once you've found those assets, you can jump on them because we talked about that prioritization. You are now jumping the line. So I highly recommend you got to look to those types of things. So in addition to that, and again, those are just letters. That's all you need to do. Attach to the UCC, send the letter. Now let's talk about some of the security interest. I think, Andy, you talked about it, so did you, Cam, related to if there's certain property involved, related to identifying the property, getting the VIN or title number correct, all those types of things. So when that default occurs, you can then go ahead and repossess that collateral. So once you've repossessed the collateral, then you must give reasonable notice to the other side as far as, hey, we received it. Under the UCC, we may be selling it in a time period of X. You then have the ability to sell it, and then you can use that against the loan proceeds. So again, that's a huge weapon to use within the context of recovering on a default. So one of the things that I think has not been identified, don't think we talked about it in the contract formation. When we talk about commercial reasonableness, that's different in the consumer versus the commercial context. So in that contract you talked about, Andy, you can actually define what commercial reasonableness is, and the courts will need to uphold it. You can't do that on the consumer side, but you can do it on the commercial side. So that's certainly something you want to consider. Now, from your guys' perspective, let's start with you, Cam. Of these remedies, how do you like the UCC as a potential remedy? Do you utilize it in your practice?
I certainly do. The UCC is one of the most important aspects of commercial collections as far as providing the creditor opportunity and ability to enforce their rights to actually maintain the secured interest on the loan. I mean, unlike consumer, we're always talking about different types of property or different types of assets, and so the UCC really acts as a mechanism, assuming all the steps are followed properly, to put that creditor in a very good position to do exactly what you were highlighting in the beginning, which is act quickly. Because in the case of commercial defaults, delay can actually be quite detrimental to your ability to recover. The UCC, namely the assignment of rents, which we know how beneficial it is, we just need our clients to understand how beneficial it is, as well as the enforcement of the UCC against other potential vendors. Both of those options are great options that I see a lot of clients underutilize that we're trying to get on the same page because of the ability to quickly recover because of how much time is of the essence in these scenarios.
And what I would suggest here is this. What we've now described for you is something you don't need the three of us sitting on the table to do for you. Probably not a good thing for an attorney or law firm to tell you, but that's the case. These are programs you can set up for yourself without attorney involvement. Now granted, we recommend ourselves to put those letters together for you, get the program ready for you, but you don't need us. These are things you can do yourself. So keep that in mind. If you get a robust program together on this piece, you're going to be hitting your collections like never before on these commercial defaults, which we hope you don't have. But then let's say, for instance, that program doesn't work. These what's on tap things don't come free. We got to buy the Delco beer. So now you got to hire us. So what's going to happen next is, what are your legal remedies? Where do the lawsuits get involved? Well, realistically, once you're talking to us, my guess is, not my guess, my experience has shown the business is done. You're not recovering from that business. If you hadn't done it already, that ship has sailed. You are coming to us to collect against the guarantor, to file a suit against the guarantor. Now, each jurisdiction's got different ways you can do it. So basically, Andy talked a bit about a confession of judgment. You can file a separate lawsuit as well. But I just want to talk a little bit about a few of the remedies that are available, because when you file a suit against that guarantor, a lot of firms will just get you a judgment. A judgment is the easy part. The hard part is collecting on that judgment. So I want to talk about a couple of remedies. Andy, yourself in Pennsylvania, bank attachments are a significant remedy. So you get a judgment against that guarantor. Tell us a little bit about a bank attachment.
So in reality, the bank attachments are the easiest way, assuming there's money in the account, to recover a significant amount of money. Essentially what we do is we request that the guarantor's bank freeze the account and then turn over the money sufficient to satisfy the judgment. And it happens in a relatively quick timeline. So I would definitely suggest using a bank attachment to go after the guarantor.
And briefly, talk to us a little bit about a wage garnishment.
Sure. So a lot of my practice in the state of New Jersey permits wage garnishments to be pursued both in the consumer context, but more importantly as it relates to this topic, against those personal guarantors that are part of the commercial contract. So, just for example, this is something not available to creditors in Pennsylvania, even in commercial loan context. I strongly urge you to check with your local rules, local jurisdiction to determine if a wage garnishment is an option to be pursued. But similar to what Andy indicated, it is a process we go through. It's handled by a court officer in the state of New Jersey, and their job is to essentially locate that employer, put a lien against those future wages. A certain percentage of it then becomes deducted based on either a weekly, bi-weekly schedule, whatever the payment schedule is for that individual who's working there. And then it's a way to get money coming in. One thing I would add on both remedies here, post-judgment enforcement remedies, is more than anything else, it gets conversation going with the personal guarantor. As you indicated, Mike, the business is likely long gone at this point. That personal guarantor is your only opportunity to really recover money in this scenario at this point in time in the process. So even though that personal guarantor has not engaged in any sort of settlement discussion up to that point in time, the wage garnishment or the bank attachment certainly will get that conversation going.
No, I would agree. I mean, conversation's the big part. So, we gave you a lot of stuff here today. I mean, the collection of commercial accounts, there's a lot going on there from beginning to end, so we appreciate it. Certainly feel free to reach out to Andy. Oh, Cam, I just realized you feel free to reach out to Cameron Walter Deane at any time for any questions as well, or myself. Our information will be provided. Also, please, we highly recommend grab some of our other content. Coffee with Casey, Ask a Pro. There's a lot of great content. Feel free to send us any of the questions you might have. Unfortunately, we didn't have time for questions today, but we can guarantee you we will get to every question you may have. And please tune in for the next episode. It looks like our next episode will be July 10th, and it's going to be Understanding Reg F, Limited Content Messages, and Call Frequency Requirements. So we appreciate it. Our great sales and marketing team, if you signed on here today, is going to send you out a PowerPoint. There's going to be a questionnaire as well. We ask you to fill that out, please. And thank you for your time. And now we're going to enjoy some Delco Lager. Thank you very much.